How to get a high grade in equity and trusts. First of all, it is very important that you analyze your exam requirements. You need to plan your revision very carefully. So every day it is recommended that you revise one particular topic and then you answer problem and essay questions on it from past exam papers. For example, if you have an exam where you will get 6 questions and you need to answer 3 out of it, how should you prepare? You can study 4 main topics you understand the most. You can choose the ones you like. You don't have to revise everything that was covered on your course, just the ones that you like and will most likely come up on your exam. For example, 3 certainties, charitable trusts, non-charitable trusts, fiduciary duties are all topics that most likely will come up on your equity and trust exam. However, it depends on the course. Sometimes they change it because they did not cover any of those topics. So make sure that you check your course, the lectures that you have had in your university, and check the past exam papers to know for sure which topics are going to come up on your exam. But most likely it will be this 4. It will be more than this, like it could be also other topics. But the best practice is to have a look at the lectures that have been delivered, as well as past exam papers, and then choose topics to revise and practice from those. Problem question style. How should you answer a problem question? You need to stick with this issue, role, application, conclusion structure. Issue is to identify the legal issues. So what is identification of the legal issue? For example, the legal issue would be to discuss if there are 3 certainties in the problem question scenario. That would be the legal issue. The rule would be to identify all the relevant statutory or case law that governs the 3 certainties. And then you need to apply the law to the facts of the case and conclude what would be the most likely outcome. You cannot give definite answers. It's not really possible in law because law is not math. We don't have one correct answer. They can be different. So your job here is to identify the correct law that applies to the problem question scenario and discuss all possible outcomes with critical analysis. Essay question style is a bit different. Here, you don't have a problem question scenario where you have to advise the parties, but you have here you have a question that you need to critically analyze. For example, you will most likely have a controversial area of law that you need to provide arguments for and against. Similarly to the problem questions, here as well, you need to discuss the law, the relevant law. It would be primary law or even secondary sources like journal articles, but you definitely need to base your arguments on something. You can't just say things. You have to back up your arguments with either primary law or journal articles. 3 certainties. Knight versus Knight is the key case where 3 certainties was discussed. In this case, it was held that 3 certainties are certainty of intention, certainty of subject matter, and objects. A clear intention to create a trust as opposed to creating something else, that's certainty of intention. There is no requirement to use a specific form of words when creating a trust of a property other than land. So it's not required to say the word trust. All you have to do is express a clear intention, certainty of intention to create a trust. there has to be, secondly, certainty of subject matter, which means that the trust property must be sufficiently segregated from other property so that the trust fund is certain. And finally, the people who are to benefit from the trust must also be identified with sufficient certainty. So these are the beneficiaries. The beneficiaries to the trust must be identified. Otherwise, if there is nobody to benefit from the trust, obviously the trust will fail. And if there is no certainty as to what is the subject matter of the trust will fail similarly. So all these three certainties must be satisfied for a trust to stand. There are some exceptions to this three certainty rule, for example, charitable trusts, but we'll go through that later. Example problem question. John died in 2019. His validly executed will contained the following provision: £15,000 for Joseph, in whom I have the fullest confidence that he will carry out this instruction to hold half of this fund on trust for my son Lucas. You can see equity model essay. We have a model essay on this problem question that you can see on our platform. You go to equity and trust model essays and it's there. But before reading the answer, the best practice would be if you try to answer the question yourself and then compare your answer to our answer. If you need any help, I strongly recommend you to book a tutoring session with us. The demand is very high due to the upcoming exams, so I suggest that you book a tutoring session with us as soon as possible. Issue 1, 3 certainties required for the creation of a valid express trust. First thing you need to say is define what are the 3 certainties, and then start applying one by one to determine if certainty of intention, certainty of subject matter, and certainty of objects exist in this problem question scenario. Certainty of intention, a verbal expression of an intention to create a trust, that would be enough. The requisite level of obligation is that the said law must have intended to impose a legal obligation on the trustee, as opposed to mere moral obligation. So trust is a legal obligation. It's not merely a moral obligation. So the wording of the trust must be enough to raise this kind of legal obligation that is required for the trust. It must be clear that he intended to create a trust and not anything else. For example, it could be a loan or it could be a gift, but the expression of the trust must make it clear that it's not a loan or a gift, but it's a trust. The definition, the distinction between moral obligation or trust was further clarified in the case of Lum versus Eames. The statement to be at her disposal in any way she may think best for the benefit of herself and her family was held to be merely a moral obligation. The approach taken by the court in this case was that to impose a trust, the statement has to be read as a whole rather than any particular word. So it's not about just looking at particular words, but it's about the whole of the entire statement. We need to look at the entire statement to see whether or not the trust exists, rather than just look at the particular words. And the word trust itself doesn't need to be used for the trust to be successfully created. This statement was made in the case of Tito versus Waddell. This is the case where it was established that the word trust does not need to be said expressly for the trust to be made. Application. Apply the above cases that we just mentioned to the problem question scenario. You can argue that this is more of a moral obligation rather than a trust, because the discretion is put on the trustee to use the trust property as he considers right. Similarly to Lum versus Eames, there is no obligation on him to spend the money in a certain way. The statement is very simple. to the one in Love versus Eames and demonstrates set loose intention to create a moral obligation rather than a trust. The fact that the word trust was used in the statement does not necessarily mean that it was a trust. You can just cite the cases. You don't have to explain what happened in these cases like Love versus Eames or Tito versus Waddle. So it depends. Like if the facts of these cases are relevant to the argument that you're making, then yes, you have to explain a little bit of what happened in those cases. However, it's definitely not required. If you're just referring to the principle that came out of that case, all you can do is just apply it and cite in the footnote or in brackets, whatever the referencing rules are for your particular exam. Charitable trust, also one of the most common topics that come up on equity exams. And very easy one to answer because there is an established structure that you can follow and it's hard to get it wrong. Charity is defined in Section 1 of the Charities Act. So you need to apply the statute, Charities Act 2011, and then apply the definition to the problem question scenario. Charity is an institution which can be a trust or a company under English law, which is established for charitable purposes only, forced to be subject to the control of the High Court in the exercise of its jurisdiction with respect to charities. There are two requirements. It must fall within the list of purposes set out in Section 3 of the Charities Act, and it must satisfy the public benefit test. Those are the two requirements. So the first thing you would do is apply the definition of charities under Section 1 of the statute, and then apply, say which specific charitable purpose would be the relevant one under Section 3, and finally apply the public benefit test. It's really hard to get this wrong, so I believe that this is probably one of the easiest questions you can have in equity and trusts. Public benefit test. Establish a trust to pay for the school fees of the children of the company's employees was not a public benefit. Lord Simmons held that there could not be a public benefit if there was a connection between the people who established the charity and the people who were intended to benefit. Therefore, the test was if those who stood to benefit from the trust constituted sufficient section of the community. So basically, this means that public benefit test needs to be passed for charity to be created. And what is the public benefit? Basically, the claimant must establish that there is enough members of the public benefiting from this entity for the public benefit test to be satisfied. The reason is that when a charity is created, that it has tax advantages. Charities usually don't pay taxes, and the justification for this is that they have to be benefiting enough people. So if the charity is only benefiting like just few people, it's not really a public benefit, and that kind of charity would not be able to satisfy the public benefit test. It has to be more people. The court has not actually said how many people should be for public benefit test to be satisfied, but they said sufficient section of the communities. It has to be many. We don't really know how many. How do you answer a problem question on charitable trust? First, you need to identify the right section from the list of purposes under Charities Act Section 3. And secondly, apply the public benefit test. There are multiple cases you may need to apply for the public benefit test. Make sure that you apply the relevant one. Not all the cases about public benefit would be relevant, just the ones that are actually similar, or if the principle in that particular case is relevant. We have as an example answer on our platform. Please go to Equity and Trust Model Essays, and we have a coursework on charitable trust that was awarded 69, I believe, almost the first class. And we usually make a statement of what level the essay is, if it's a 2-1 or first class, and you will see it there. Please go to Equity and Trust Model Essays and check out our sample answers on charitable trusts. For further information, please book a tutoring session with us, and our tutors will help you understand step by step everything that you need to know about answering a problem question on charitable trusts. Most likely, you will get a problem question. It is possible you get an essay question about charitable trust, but less likely. Like 90% of the times I see a problem question about charitable trust. So I believe you should be well prepared to answer a problem question on this topic. There are also non-charitable trusts, otherwise called purpose trusts, and that also very often come up on equity exams. And if you have an equity exam, I believe you should prepare for answering a problem question about this as well. There could be an essay question, but more likely it will be a problem question. But to just be sure, I recommend answering both. So practice answering both a problem question and an essay question before your exam to be prepared. Express trust, resulting trust, and constructive trust are all trusts for ascertainable individuals. Non-charitable purpose trusts are sometimes referred to as private purpose trusts, and that's why they are void. The reason why they are void is that because they don't satisfy the 3 certainties requirement. Remember, there has to be certainty of intention, certainty of subject matter, and certainty of objects, beneficiaries. This is a purpose trust. It doesn't have a beneficiary, so that's why it fails. But charitable trusts are the exception to the 3 certainties rule. It does not satisfy the certainty of objects requirement, but despite that, it can still exist because it's for charitable purpose. Why are most private purpose trusts void? Lack of beneficiary. If there is nobody to be benefiting from it, then the trust cannot exist unless it's a charitable trust. Uncertainty. Courts are unable to supervise or enforce a trust if the terms or objects are uncertain. The perpetuity rule. The rule requires a future interest to be vested in a beneficiary within a certain time. So the idea is that the trust cannot last forever. There has to be an end. According to the Perpetuities and Accumulations Act 2009, the perpetuity period is 125 years, and it cannot be more than that. Whereas for the purpose trust, the perpetuity rule does not apply. Because there is lack of beneficiary, the purpose trust could last forever. So it does not comply with the perpetuity rule. And that's one more reason why we don't want a purpose trust to exist. This is against the public policy that property capital should be capable of circulating in the economy, the rule against inalienability. The beneficiary principle. There must be a beneficiary in whose favor the trust can be exercised by the court, and there must be beneficiaries with property rights in the trust fund. A trust without a beneficiary cannot exist unless it's charitable. There are many important case law that you need to remember about this topic, but most important are Re-Astor Settlement Trust, Re-Shaw. I believe these are one of the most important cases. I have put the links here. We have case summaries for these cases. So please go to Simple Studying, check this Re-Shaw case will come up. We have a search bar at the top, and if you just type there, you will find it. Fiduciary duties. There is one more topic that you could get on your exam, equity and trust exam. Example of fiduciary relationships are trustees and beneficiaries, principal and agent, company and director. And there are strict obligations. When somebody is a fiduciary, they have strict duties to adhere to. Summary of the legal position for fiduciary duties. No profit should be made out of a fiduciary position. Fiduciary must not place himself where duty and interest conflicts. Fiduciary must not act for the benefit of a third person, only if they get a valid permission for that. Directors of the companies must ensure that there is no direct or indirect conflict of interest. Director must not accept a benefit from a third party. If there is any possible conflict, the company must be notified. If there is a specific provision, common law overrides equity, and these duties are under Companies Act, owed to the company and not to the shareholders. So these are fiduciary duties that are the same for company directors and the company, as well as the trustees and beneficiaries. The people in fiduciary positions cannot take advantage of their positions to profit from their position without the permission of the beneficiaries. Important cases to read: Regal Hostings, one of the most important cases about fiduciary duties. Industrial Development, Influence Group Ltd versus Pike. All these cases are published on our platform. You should read them to be well prepared for your equity exams and to be prepared to answer a problem or essay question on fiduciary duties. But most importantly, please remember that when you get a problem question or an essay question about any of those topics that we just talked about, don't write everything you know about it. Answer the question asked. It is very easy to go off topic. There is a temptation to write everything you know so you can give all the knowledge you have, but that doesn't work that way. You won't get a good grade if you just write everything you know about the topic. You have to answer the question, whether it's a problem question or an essay question. Make sure that you do as they instruct you. If they tell you to critically analyze whatever area of law they are referring to, then do the critical analysis, argue for and against the statement. Now, if it's a problem question, then advise the parties. Make sure that you identify the legal issues in the problem question and find the relevant law, apply it to the facts of the case. Answer the question. Don't forget to practice. If you just know by heart all the laws about this topics that we just covered, you only have done 50% of the job. You most likely won't get a good grade if you don't practice. I know you don't have enough time and it's really hard to practice and you have to learn everything, but you have to make time to practice. Revise first. For example, when you're revising charitable trust, you can go to our platform, read the notes, revise the entire topic, make sure you're familiar with the key cases, you understand the key concepts, and then find a model essay we have on charitable trusts on our platform and practice answering it. First, draft the answer yourself and then compare your answer to our answer. It's very important that you practice answering to both problem and essay questions for all the topics that you have to revise. But most likely you will need help for that. Most of the students need. So please go to our platform, and if you click tutoring at the top, you will be able to book a tutoring session with our tutors. Now I'd like to spend just a couple of minutes to explain to you how we can help you. At Simple Studying, we have a team of top graduates who got very good grades, content creators and tutors. They create study materials on our platform and deliver tutoring sessions like this one and one-to-one as well. They come from many different universities from England, such as the City University of London, LSE, BPP, Keele University, University of Leeds, and others. We're not associated with these universities, but we do hire their best graduates. In addition to the ready-to-go first-class study materials that we have on our platform, we offer personalized one-to-one tutoring where you can learn how to get high grades, practice legal writing, get guidelines on exams and courseworks, anything you may need for your legal studies. We already have 25,000 customers from the UK studying on our platform, and 90% of our regular customers who are on premium plan and get tutoring sessions reported to have got a first class. If you want to be the next success story to have got a first class law degree, please sign up now. Thank you very much.